out that we have allotted 20 minutes aside, but arguments routinely go beyond those 20 minutes. If we are continuing to ask questions, please feel free to continue to answer without asking permission to go forward. Would ask that if there are no questions pending and you see that your time has elapsed, that you quickly wrap up. For those who might be watching, just want to emphasize that the fact that we have more questions for one side or the other is not a reflection of anything other than just where we have questions, and is not any sort of indication of how we're thinking about the case. So if I could please get counsel to state your appearances.
Natalie Skabeen for Mr. Hunt.
Morning.
Connor Nelson for the state of Utah.
Good morning. All right, let's begin.
May it please the court, again, Natalie Skabeen for Mr. Hunt. I'd like to start with our argument that the court should have given the instruction stating that actual danger is not necessary to establish self-defense. First, the instruction was correct. This concept that actual danger is not required was articulated in Turner. There's an example of the instruction in the Starks case, and the concurrence in State v. Lee explains in detail how a reasonable mistake of fact applies to both self-defense and imperfect self-defense. Even in the recent Court of Appeals case, Devon, the district court and the Court of Appeals recognized that the instruction, which was similar to the one requested in this case, is a correct statement of law.
But of course, the court could give lots and lots of instructions that are the correct statement of the law. So even if we agree with you that it's the correct statement of law, doesn't the district court have discretion not to elaborate on points so long as the instructions that are given to the jury are correct and reflect the defendant's theory of the case?
So this is a good case where it provides an example of how the statutory language and the instructions that were given were not clear enough to explain this concept. Both the state and the district court claimed that the instruction that the defense proposed would conflate imperfect and perfect self-defense, where in fact the instruction explains a concept that applies to both perfect and imperfect self-defense. The statute and the instruction stated that, or the statute and the instruction that was provided, not the proposed one, stated that force is justified only if the individual reasonably believes that force is necessary to prevent death or serious bodily injury. And that just leaves kind of fuzzy the question of whether someone can reasonably believe force is necessary in the moment when hindsight reveals that there was no actual danger. And in addition to being just unclear in the language, it also is an area where people have different policy viewpoints on this. Defense counsel in closing mentioned that police officers don't wait to see a weapon before shooting, so that could also impact the jury's reading of the statutory language, and it's part of why the instruction was necessary here.
So what's the standard then? What's the principle we would articulate? I mean, it can't be if the language is fuzzy or people might have different policy viewpoints. I mean, what is the standard against which we would judge whether a district court erred in not giving the extra instruction?
If the language is confusing and the facts support the clarifying instruction, it should be given.
Okay, so what is confusing about this particular language?
It's that reasonably believes that force is necessary. The case law makes clear that that can include a reasonable mistake, but the jury is not likely to pick up on that and to think that, well, there was no danger here, but he still reasonably believed that there was. Or they might think that that's a question for them to determine as opposed to a question of law for the court to explain to them.
Does that make it confusing, or is it just that it's omitting something important? Because I'm not sure why someone's confused by this. Some of our cases will have two instructions, and if you read them together, maybe it creates some confusion. I'm just trying to figure out why that's confusing.
I think it gets to the same place, whether it's an important omission or it's confusing. If you just read the language, it is not explicit that a reasonable mistake applies in this circumstance. So it's confusing in the sense that the jury could get back and one juror could say, well, it was a reasonable mistake, and the other one could say, but it's not reasonable if it was a mistake, and this instruction would have been clarifying on that point.
Why wouldn't this just be something appropriate for defense counsel to argue based on the instructions that were given? When it says, only if the defendant reasonably believes, why wouldn't this be something to elaborate on in argument, that reasonable belief, doesn't require that belief was correct.
And this is something defense counsel pointed out when arguing for the instruction, which is that if he doesn't have an instruction to point to, the jury is also instructed that whatever counsel says is just argument. It's not the facts, it's not the law. You're to rely on the instructions if there's any conflict. So defense counsel can give his best pitch for it, but it's not the same as having the jury instructed on the law.
Well, I completely agree, of course, that if it conflicts, but I'm just not sure that that's a conflict. When the instructions say reasonably believes, I don't see anything in the instruction that would suggest to a jury that belief has to be correct.
I think that it's an omission, and there is some confusion there with a phrase like that, like reasonably believes. And it's, again, an example is when the court talks about how this conflates perfect self-defense and imperfect self-defense, or how the cases where this concept was articulated are outdated. There's just room in the statutory language to think that this instruction, which was clarifying and explicit, needs to be given.
How do you think that we should treat the district court's comments about why it didn't give the instruction? Does that necessarily matter, or are we only reviewing the ultimate decision of whether to give it or not? So let's say we agree with you that maybe the district court misunderstood the law. How does that affect our ultimate decision in this case?
I think in two ways. One is the abuse of discretion standard. If the court's making an error of law, that's necessarily an abuse of discretion. This isn't a case like Devon, where the district court said, well, this is a correct statement of law, but it's the wording that I'm going to give, within my discretion to give this wording instead of that wording. And then the second reason it matters is just because it's an example of the confusion in the statutory language, where even experts in this area are not sure whether this instruction applies. When it does apply, it is a correct statement of the law.
I think your second point, I think that's a solid point. I want to ask you a question about your first point. We do have at least one case that I can think of that I can never remember the name, where we're talking about the admission of evidence, and we say that even if the district court admitted evidence for the wrong reason, there was a mistake of law, what we're reviewing isn't necessarily the court's reasoning, but the court's ultimate decision. So how would this be different than that approach?
Well, I think it's kind of similar to the line of cases about when instructions are necessary and when we're just reviewing the wording. And our argument here is the same, whether it's abuse of discretion or whether the question is whether the defense was entitled to the instruction. And that argument is that the statutory language alone is not clear enough. And so the court doesn't have discretion not to give some version of the explicit language in the defense's requested instruction.
So I've been wondering whether the district court had any wrong legal reasoning in making the decision and how relevant that is. And it's all on the record. And when I see myself on a record, I think, I thought I sounded a lot better than that. So I give some grace when looking at transcripts because it's all off the cuff. But to me, so I'm just looking at the first time that this was discussed, and then the court went and read the cases again and discussed it again the next day. And to me, it looks like the court is talking about the case Turner, because that was the case that was given to support this instruction. The court is wary of relying on Turner because it is talking about a very different statute. It's talking about necessity, and focusing on that word instead of reasonable belief, which is what's in Agwell. We also do have necessary, but the language in Turner just was very different, so it seemed the court was wary of relying on Turner. But the court also seems to say at various points, I think this is already covered in the current instructions.
That's right. The court said both things. But I think that that first point that, well, this is relying on Turner on this specific issue is still good law. It's the same concept that's articulated in the Lee concurrence or in Devon. And the law wasn't so different in Turner that it's not helpful. It's similar enough on the concept of self-defense. And on this specific issue, it's still correct.
Yeah.
And then the court also said, well, it's covered enough in the instruction, but then that led to, so you can argue it, which is where we get to defense counsel saying, but I need this instruction to make sure the jury knows what I'm saying is correct.
Yeah, I just thinking back to being in this type of situation, jury instructions is really not the time you want to be creative as the judge. You want something that's tried and true and is not going to cause problems on appeal. And I can sympathize with looking at a case like Turner, which is talking about a statute that's very different, and instead of using the terms that we're using now is talking about necessity, you would be wary of relying on that as a jury instruction, even though it's still good law on this particular point. And so I can kind of understand that in the context of deciding what jury instruction you want to use. And I wonder, so the instruction proposed by the defense here is not a model of clarity. Even though it was in the Starks case, I don't know that the court in Starks blessed the particular jury instruction, and it has some errors. It's kind of modified the language from Starks, so it's less clear than what's in Starks. It's added some language in there so that I had to read this instruction multiple times to figure out what it was trying to say. And so how much do we consider the actual language that the defense is proposing? If this would have been, 2 sentences saying just the very specific point of law, apparent danger is enough, it doesn't have to be actual. That might be different, but here the court's presented with a 1938 case to justify language that's not super clear in a jury instruction. I'm not sure what we're supposed to do with that.
Well, to start, I think that defense counsel can look to the case law, find an instruction that's been given in another case that seemed to be, if not, if the court in Starks didn't say this had to be given, it at least said it was given and seemed to say that it was articulating the concept correctly. So that's why defense counsel's instruction looked the way it did. And that's when we get to the abuse of discretion standard for the wording of an instruction. Mm-hmm. If the court had said, well, this concept is correct, your instruction is long and confusing, can we just reword it together? Or I'm just going to give this instruction in 2 sentences. I don't think we'd have the same case that we have. We'd have a case more like Van Ostendorp, where the court said, I'm going to put it in my own words and I'm going to include your concept, but not your exact proposed instruction.
I wanted to ask you about the standard of review for this particular situation, where a court declines to give a jury instruction. In looking at case law about the standard of review for jury instructions, it's a little bit all over the map when you just look at the snippets of the standard of review based on what the issue is that's arising. So obviously, if someone's challenging a jury instruction as being inaccurate or an inaccurate statement of the law, then that's reviewed for correctness. There are cases saying a judge's refusal to give the jury instruction is reviewed for abuse of discretion, which is the standard you've got. Except I guess if there might be situations where a refusal to give an instruction, if it makes the jury instructions legally incorrect, would be reviewed for correctness. So in hopes of maybe clarifying the standard of review in this situation, do you have any thoughts about the best way to kind of articulate what the standard of review should be in this situation where you're not arguing that the jury instructions, that the refusal to give this made the instructions incorrect. You're saying that this additional jury instruction would have made it more clear, would have clarified the jury instructions. What's the best way to formulate a standard of review?
So the case law said that when the defendant is entitled to the instruction, then discretion is sort of narrowly cabined. And here our argument is that we can use the abuse of discretion standard, but then under that standard, a court doesn't have discretion to rely on statutory language if that language can be misconstrued and the defense has proposed an instruction that is backed by the facts in the case that would provide a necessary clarification.
So the standard is if the language can be misconstrued.
If the language is confusing, if it's incomplete, if the instruction is needed to clarify the statutory language.
Okay.
Can I ask you about prejudice on the jury instruction question? One thing I was wondering, I looked at the instruction on imperfect self-defense, and one of the sentences there is, let's see, it applies when the defendant caused the death of another while incorrectly but reasonably believing his conduct was legally justified or excused. I'm just wondering here as a practical matter, if the jury had been confused on the point about whether or not whether there actually had to be a gun in order to find perfect self-defense. It seems reasonable to me to think the jury would have convicted of him of imperfect self-defense if that was their thinking. And I'm just wondering what you think about that.
Yeah, and that was the confusion in the state and the court's thinking about the instruction, is that it applied more to imperfect self-defense than to perfect self-defense. But it applies to both because both require the reasonable belief that the conduct.
And I
legally
agree with you
justified.
from a legal point, and I could see maybe some confusion by the district court. I'm just trying to think of what I think this jury would have done had they received the instruction you requested, right? And it just seems to me that this jury, if this had been their point of confusion, they were in the jury box and saying, ooh, I think it was reasonable to believe he had the gun, but he was just wrong about that, so I can't find perfect self-defense. It seems to me like they would have relied on that instruction to conclude.
But not necessarily where the reasonability applies to both. That part applies to both. The reasonable mistake of fact applies to both perfect and imperfect self-defense. So what they could have done is said, well, he didn't have a gun, so there was no imminent threat here, so he couldn't have possibly been reasonable when he fired his weapon, so neither of these apply.
Okay. But the imperfect self-defense talks about it being incorrect belief.
But that applies to the legal justification.
I understand it does, but I'm not sure the jury would have understood that.
Well, there's a reasonable probability that they would have understood the legal mistake aspect of imperfect self-defense, but not the reasonable factual mistake of both self-defense and imperfect self-defense.
It looks like we're out of questions for the moment.
Thank you.
Mr. Nelson?
May it please the court, Connor Nelson for the state. Defendant did not suffer prejudice related to this jury instruction claim. That's because there is no reasonable likelihood of a different result, even if trial had unfolded with this instruction given. The evidence showed that the defendant unreasonably used lethal force here. He first verbally threatened the victim, and then he hit him in the head, and then he killed him as the victim got out of his seat to address the person who had just hit him. Defendant could not claim any form of self-defense here because he was the aggressor, and he unreasonably escalated this encounter into a deadly shooting, even though the victim posed no threat to him. And so, as I take the argument has unfolded so far, there's no real claim that the jury received legally incorrect instructions. And the case law seems to suggest that in this situation, the district court has more discretion to decide on the wording that it decides on for the jury instructions here.
You know, the one thing that our case law doesn't say directly, that I think maybe is missing is, it talks about how the court has discretion about the wording and the form of jury instructions, but I'm not sure if we've ever actually said in a case that the district court has discretion to decline to give a particular instruction that either side offers, so long as the jury instructions that are given are adequate, right? They're legally correct and they're adequately complete. I say adequately complete because, you know, I think there could always be an argument that they could be more complete. So what is your response to the question that Justice Peterson posed earlier about how we review a district court's decision? Let's assume that the instructions that were given were correct, and a party asks for an additional instruction to elaborate on a particular legal point. How do we review that?
Well, I'll just begin by noting that neither side really developed arguments on the particular standard of review for this issue. So if the court is really concerned about what should apply here, then might I suggest supplemental briefing could be appropriate. But given the case law that we do have, I recommend this court look at State v. Maestas for one example, and that's where the court said it's important that the jury instructions fairly instruct the jury as to the applicable law. State v. Nelson gets to this idea that the jury instructions certainly could be more complete, but as long as the jury instructions advise the jury on the appropriate law, then it's not an error that they could have been more correct. And again, we have these legally correct instructions here, and so we're in a situation where the district court has more discretion to finesse the language into what fairly instructs the jury about the appropriate law.
Let me just ask it really clearly, because I practiced under federal law for a long time. There is 10th Circuit law that says expressly that as long as the jury instructions are complete, the district court has discretion on whether to give a particular instruction offered by the parties. Is that something that this court should adopt, that type of standard of review in this type of case?
Certainly coming at it cold, I again suggest supplemental briefing to fully analyze that. But given the case law that we do have from this court, it seems more of an abuse of discretion. Particularly last year, this court said in Meeks v. Payne that if the instructions, quote, correctly state the law, the precise wording and specificity of jury instructions is left to the sound discretion of the trial court. So just given that, I would say the standard of review is abuse of discretion in this situation.
It's difficult for me to see a different one, only because I think there could always be an argument made that additional instructions might be helpful or might clarify or could assist the jury. But you've answered my question. Thank you.
Can I ask just one additional standard of review question? When do you think that the standard of review on a jury instruction issue is for correctness, and when should it be abuse of discretion?
Again, this is a little bit of a difficult question since we haven't fully explored a standard of review issue in the briefing.
Okay.
But just given what the state of the case law is, there tends to be more of a concern when there's a legal error within the instructions, or in the case of Hutchings that my friend on the other side relies on, there's potential confusion within competing instructions that could lead to an error in how the jury interprets it. But we don't have that kind of situation here. We just have the straightforward instructions explaining that perfect self-defense applies when the defendant reasonably believes he needed to use lethal force and he'd be justified. We also have the imperfect self-defense instruction where he reasonably believes he needed to use lethal force. And nothing in those instructions that were actually given to the jury would have been confusing to apply.
Do you think that the district court's reasoning, even if the court arrived at a correct result and decided it wasn't needed and the jury instructions are complete as they are, do you think that any of the court's reasoning for why it made its decision was legally incorrect? And if so, does that matter?
Well, I don't think it matters in this case because the district court actually was correct, recognizing that the proposed instruction was just another perfect self-defense instruction. The additional reasons, I think, are additional reasons. If we actually look at the instructions language directly, you can see where the elements of perfect self-defense can be found. They're all in the second sentence. Just to start with the proposed instruction, and I'm going to be quoting directly here. If one is confronted by the appearance of peril, which arouses in his mind as a reasonable person, and he believes that he is about to suffer death or serious bodily injury. That's the reasonableness, the reasonable belief section of perfect self-defense. And then continuing on from that instruction, and if a reasonable person in a like situation, seeing and knowing the same facts, would be justified in believing himself or another in danger. So the proposed instruction says that a person would be justified. That's the other half of perfect self-defense. So the jury reading this instruction would have the same parts of perfect self-defense that it received in the actual instructions given to the jury. And since these concepts were already conveyed within the perfect self-defense instruction, the district court did have discretion not to duplicate those points, and that's in my estis.
Let me follow up with Justice Peterson's question, though. Let's say that we disagree with you and that we agree with the defense that perhaps the district court misunderstood the law on this point. Does it matter?
I don't think it does matter because this court has the ability to affirm alternative grounds, given what I've explained about what the jury instruction actually explained, that this is just another perfect self-defense instruction, just worded a little bit differently and a little bit more archaically. The district court does have the discretion not to give that duplicative instruction. And if the court recognizes this reasoning isn't in the district court's stated grounds for denying the instruction, it can affirm based on what I've explained here today.
So would we be saying that if the court had had a different rationale, that wouldn't have been an abuse of discretion? Is that how we would look at that?
Given the context within the jury instruction issue, that there's no claim these were legally incorrect instructions, we're in abuse of discretion.
No, I mean, I understand that it's an abuse of discretion standard. You said we could affirm on alternative grounds. So I'm trying to figure out what those alternative grounds are. And at least as the way I was understanding what you were saying, it would be to say, well, this might have been the wrong reason to deny this jury instruction, but there is a right reason to deny it. It would not have been an abuse of discretion to deny it for a reason we can imagine, and therefore we'd affirm. Is that how we look at that?
I believe that's correct, Your Honor, just given the unique contours of this issue. And again, the standard of review hasn't ever been fully briefed in this particular case. So if the court is interested in exploring that issue more, but I don't think it's necessary in this case. The district court actually did recognize this was a duplicative instruction. I unfortunately don't have the particular record site in front of me, but I do recall it being in the record. And if you want me to
No,
provide point by
that's
J on
fine.
that.
I'm going to ask a different question. So sometimes in jury instructions, if they state the law, say they quote from a statute, but a statute might be a little bit confusing, or at least maybe our case law has expounded on that statute to make a particular point more apparent, right? And if someone proposed a jury instruction that just, quoted the statute, and someone said, well, that's great and it's correct, but the way the courts have talked about that statute, it expounds on it, and there's this additional point of law. I want that presented to the jury too. Would a defendant have the right to have that presented, or would we just say, well, the first instruction cites the statute correctly, and that is the law, and so the second one need not be given? I know that's very abstract,
Yes.
but it's kind of in this case, right, where they're saying this might be an accurate statement of the law, but our law has further explained that a mistake of fact about the threat is something that doesn't prevent self-defense from applying. And so they're saying we need that. I think what she was saying is, that it's a material omission, essentially, that needs to be presented to the jury because otherwise they don't really have the full extent of the law.
Certainly, there are some cases where additional explanation beyond statutory language is appropriate. I think the reply brief identifies a few examples, but self-defense is not one of those circumstances. The ultimate question in front of the jury is whether the defendant acted reasonably in using lethal force here, and that's adequately explained within the statutory language and the additional instructions defining what reasonableness is. They received that instruction on Record 640, the additional definitions, the factors for when something is reasonable. All these additional instructions informing the perfect self-defense instruction and the imperfect self-defense instruction, all of that provides everything the jury needs to evaluate the question placed before it.
Can you point to me to where in those factors that would have helped in those other instructions, you talk about how that would have helped the jury understand this particular point?
Actually, this is what the Devon case from the Court of Appeals gets to. We have a pretty similar, almost identical instruction. In fact, the first two sentences from that proposed instruction are exactly what the defendant here wanted. And just following what Devon said, you see that the reasonableness instruction covers the actual or apparent danger idea. If you look to paragraph 35 of that opinion, this is what the Court of Appeals said. But even without the words actual or apparent, the jury was adequately advised of the relevant legal question. Namely, what mattered was the reasonableness of Devon's belief that it was necessary for him to use force to prevent death or serious bodily injury. The idea is that the reasonableness instruction already embraces that. So there's really nothing else the court needs to provide the jury to evaluate that reasonableness issue. They're going to be evaluating what they think happened. And in this case, defendant was the aggressor here. He's not going to be able to claim self-defense. He's the first to threaten any unlawful force. He's the first to employ unlawful force when he hits the victim in the back of the head. And then he escalates the encounter again to a deadly encounter when he pulls out his gun and shoots, when there's no apparent threat that he needs to respond to.
I just have one question about what you just said. Was there another reasonableness? Was there a definition of reasonable belief? Another instruction given that you were just referring to?
Yes, on record 640 is the reasonable belief instruction.
Okay.
And to quote the relevant parts, reasonableness shall be determined from the viewpoint of a reasonable person under the then existing circumstances. And that embraces, in addition to the perfect self-defense instruction, the idea that you're evaluating the situation from the defendant's position and whether that belief you need to use lethal force was reasonable. It wasn't in this case.
And you don't think there's any risk that a jury would conclude it was necessarily unreasonable because he didn't actually have a gun?
Not on these facts. Defendant's testimony is the outlier here. He's presenting different facts on many key points, but he's just not supported by anybody else. If you look at the other two witnesses who were right next to him, they see a completely different set of events unfold. They see the defendant make the threats. They see the defendant hit the victim. They see the defendant pull out his gun and shoot after he hits the victim and after the victim is standing up in reaction to the unlawful force being hit in the head. And so since he's the aggressor here, self-defense is off the table. And he's also unreasonably using force, the lethal force, just given that there's no apparent indication, no one else saw any weapon, no one saw the victim behave the way the defendant's testimony portrayed him. He's all by himself on that point.
But let's imagine the jury believed the defendant, right? They believed that he didn't hit him in the head. They believed that there was this, aggressive, well, I don't know if aggressive is the right word, but he turned around, reached back, looked like he was grabbing a gun. Let's assume the jury believed the defendant. Is there any risk that the jury would read that instruction and think, well, because the victim didn't actually have a gun, it was an unreasonable belief that there was danger?
So in the hypothetical where the jury were to believe the defendant, I could conceive of some potential level of self-defense applying, but he's not going to be believed in this situation. There's no reasonable likelihood the jury will believe him, given all the evidence that cuts against his view. There's no real support for him other than his own statements.
But I think that gets to prejudice, right? But I'm just wondering if it means that the instruction should be given, if there's a risk that if the jury accepts his testimony, that they'll still think there's no self-defense because he was mistaken about the presence of a gun.
Could you repeat the question?
Sure.
I'm just trying to ground this in the
I'm just
actual
trying
standard
to
here.
separate error from prejudice, right? And so
Right.
I'm just saying, let's imagine the jury is going to believe defendant's testimony. Is there a risk based on these instructions that the jury could believe everything he said, but reject self-defense because the victim didn't actually have a gun? There was actually no danger that needed to be responded to with lethal force.
There's still no risk of that happening because, again, the idea of no apparent or actual danger, that's embraced in the reasonableness view. And the jury could still think that he acted unreasonably on the evidence presented. If they were to accept parts of defendant's testimony, they can still evaluate those instructions for reasonableness, see if he's behaving reasonably in their view, and reach a different result than what was here. But just given all the evidence that was here, I'll just reiterate once again,
Sure.
that's not going to happen here.
Okay.
And then have one more point to address on prejudice for this issue. As the argument before me noted, the closing argument the defense gave actually did present this point to the jury. Record 1422-23, defendant is explaining that there doesn't actually have to be a gun. As long as I think I'm in danger based on how the victim is behaving, then I can reasonably use force. I reasonably believe I'm in danger. Certainly we don't think that happened given everybody else's testimony. But in terms of not being able to present his theory to the jury, that didn't happen. He clearly explained his theory of the case using the reasonableness instruction, using the perfect and imperfect self-defense instruction, and that's all that he needed to do. Again, the ultimate question in front of the jury is whether this use of force, of lethal force, was reasonable. For all the reasons I've explained, it wasn't reasonable.
So how do you respond to counsel's argument that certainly they were able to make that argument to the jury, but they were disadvantaged that they didn't have a jury instruction to point to say, this isn't just me, this is the law, and let me show you how this points into the law, given that the jury was also instructed that anything counsel says is just argument and isn't the law. And so they were placed at a disadvantage with that argument.
I don't see any disadvantage in there at all because the question in front of the jury is still the same. They're still evaluating whether or not this lethal force was reasonable in the situation. And this is just an added detail that counsel is going to be arguing and explaining why it's reasonable. That's the same whether or not there's an instruction.
Because they would just go back to the reasonable belief language in the instruction?
Exactly. It's all going back to the reasonable belief, which is the question in front of the jury. And that's already presented with the instructions they have.
Can I ask you a question about the next issue? Can you tell me how long the video or the 911 recording was?
Based on the exhibit in the record and where it was cut off, I estimate the entire call played was about 4.5 minutes.
Okay, that's helpful to me. I have to admit I'm struggling a little bit with the deficient performance argument on that one. This does seem like it would have a tendency to arouse the passions of the jury, and I realize that just because someone could make an objection that is meritorious isn't enough. I'm not sure I bought your argument that maybe a defense counsel would have a strategic reason not to object during trial because it could have been in a motion in limine before trial, as defense counsel has pointed out. So it seems to me that really the only issue here is whether this is a battle that a reasonable defense counsel would have fought. It's really hard for me to conceive of any, like, for instance, strategic reason or anything like that to not object. So can you address that? Why isn't this something that a reasonably competent defense attorney, this would just be a no-brainer? Why would they allow the entire call to come in?
Well, 3 points, first of all.
Okay.
In reviewing the exhibits from trial, there was a section of the call that wasn't played, so they only heard about 4 minutes of about a 5.5 minute call. Second, the competent counsel evaluating that 403 objection's strength could recognize there's quite a few points of probative value within the evidence within that 911 call. It's probative of BH's movements after the shooting happened. It's probative of the fact he gave CPR, which could inform victim's body's condition at the time police find him or the autopsy. It's probative of BH's own credibility because he's testifying, he's saying what he did, he's explaining what happened. It's another piece that could be used to inform his credibility because it is attacked on the defense side, so the state can use it to explain, no, he is credible about what happened.
And can you tell me why there was a need for evidence on, like, the timeline and people's movements? I'm just not sure I completely understand that argument. When you're saying, can you just explain that a little bit more to me?
Sure. So when the state presents evidence, it's presenting evidence of an entire transaction of events that happened. And every piece of that is explained to the jury in some detail what happened between these people. And some of that can include things that happen after the immediate shooting. Some of it's also related to explaining when the death happened. And the case law, particularly State versus Verde, this is a part that wasn't abrogated by Green, recognizes that the state can admit broad narrative value evidence to explain its case. And this is just a piece of that.
I completely agree. And I think that there would be no question that the state could say, and what happened next? Did you provide CPR? That sort of thing. But where you have this really emotionally charged audio recording that is likely to arouse the sympathy of the jury or the passions of the jury, can you make your best argument that wouldn't have been excluded under 403? It's hard for me to understand how that isn't a meritorious objection. And I know that's not the final consideration. Just because an objection would have been meritorious or would have been granted certainly doesn't necessarily mean it was deficient performance not to make the objection. But I just can't, I'm having a hard time with the probative value here.
Well, competent counsel could evaluate that probative value a little bit differently.
Okay.
And if you listen to that exhibit, the degree of emotion on BH's part, he's pretty even toned throughout the whole thing. Certainly there's a note of stress within his voice, but a crime scene is going to be stressful. A violent crime scene is going to be stressful. And so the jury would recognize that, hey, this is a violent crime, something stressful happened, so that degree of emotion is going to be expected, and it's not a piece of unfair prejudice. That's just the nature of the transaction happening here.
And I appreciate your comments on the degree of prejudice, but I'm still on probative value. Can you point to anything after he said what happened and that he's on the ground bleeding that is probative?
Again, it's probative of the entire transaction here. It's still probative of the fact of when the victim finally passed away. He hadn't passed away immediately. And those kinds of details, I'll concede that they're not the most, like the extremely probative things of proving identity and so on, but it's still probative of other information of things like when the defendant left, he didn't stay to help out to give CPR. If he was present at the scene after the fact of the shooting, one could reasonably conclude if he had acted in self-defense, he might want to stay and render aid. But since he's not there, that supports inferences about the reasons he fled the scene.
So, for example, the statement when the operator says, is there someone else to hold down the cloth? He says, it's just the people who work here, me and my friend. That's what you're referring to there?
Yes.
Okay.
And then I have one additional point on the deficient performance analysis as a whole. The opening brief only used the word object to explain what counsel should have done. I saw the motion limine argument for the first time in the reply brief. So I was just responding to the argument, and that was presented in the opening brief. Unless the court has any questions.
Looks like we're out of questions.
Thank you, Your Honor.
very
We
much.
ask the court to affirm.
Thank you. Ms. Gavin.
Thank you. I'll start with the question about the federal cases that say that if the instructions are complete, then it's a matter of discretion for how to word them. And I don't think that's wrong under Utah law, but it just raises the question of when the instructions are complete. Because as we point out in the briefing, there are situations where the statutory language itself is not complete. It's not a reasonably complete articulation of the law in an area. The example we used was the Lewis case, where the old version of our statute had the language indecent liberties that had been defined in case law. But giving that statute as correct, it's the statutory language, but it's not complete because it's confusing and it omits a definition that the case law has said applies.
And I appreciated your statement of the standard of review in your brief about quoting Miller, the refusal to give a jury instruction is reviewed for abuse of discretion, although in some circumstances that discretion will be narrowly constrained. And then we recently said what that means, when it will be narrowly constrained, is unclear. So is that the test that you're proposing, is that the abuse of discretion is narrowly constrained when there is a likelihood that not giving it might result in confusion to the jury?
That sounds good to me. I think it's sort of two roads to the same place. The judge doesn't have discretion not to give an instruction that would clarify a confusing statute, or you could say that it's that your discretion is more constrained in a situation where the statutory language does not completely explain the law. It gets to the same place, I think.
Okay.
I found the state's argument about the proposed instruction being duplicative of the self-defense instruction to be persuasive. It seems like this instruction has a potential to introduce some confusion because it's giving a second instruction that's talking about other points of self-defense, not just that apparent danger is enough. So then you end up with two self-defense instructions worded slightly differently. And I'm just wondering, I mean, don't we just look at the instruction that was proposed and decide whether it was an abuse of discretion to admit that in the form proposed by the defendant?
Yes, whether it was an abuse of discretion not to give the instruction that the defense requested. I think that's the question. And our argument is that it was because it clarified this one important point that was really the heart of the case for the defense. But then the court would have had discretion. It wouldn't have been an abuse of discretion to modify that language if the court thought it could do better.
Okay. I wanted to ask, do you think that the district court made mistakes of law in its reasoning? And if so, what particular things did the court say that you think were mistakes of law?
Yes, I think that talking about Turner and Starks as old statutes that are no longer relevant to our current self-defense statute and to this particular aspect of it is a mistake of law. The language in Turner about actual and apparent danger is still good law. And then the second one was, and the state said it too, that the instruction defense proposed conflates imperfect self-defense and perfect self-defense, when in fact it articulates a clarification that applies to both imperfect and perfect self-defense.
Okay. But the cases we're talking about, old statutes, this language from those cases may have survived, but they were talking about old statutes.
The statute has changed somewhat. It was not on the point of when to use force in defense of aggression and force. It's pretty similar on that aspect. And then it had some other language about when you can use force when someone's like entering your habitation, which wasn't the only reason that the court was talking about actual and apparent danger.
Okay. So, all right. So it's the statement that the cases we're talking about, old statutes, and that it conflated perfect and imperfect.
That's right.
Okay. Do you remember where that was? Was that the first time that the court talked about it, or was it when the court came back?
I think it was both times.
Okay.
It's definitely in the addendum.
Okay, that's okay.
But the addendum includes both
Okay, and
transcripts.
does it matter? If hypothetically we decided no, the ultimate decision to not give the instruction was fine.
I think it does matter. And I think the case law that talks about how the judge can get the right answer for the wrong reasons, or we look at its ultimate determination, talks about not like micromanaging some of the smaller decisions in the middle. But if the judge's call is reviewed for abuse of discretion and the exercise of that discretion manifested some kind of misunderstanding of the law, for example, if it's a 403 question and the judge said, well, this is just, so probative of some element that doesn't exist in the statute, I don't think that should receive deference from this court anymore.
Thank you.
We'd ask the court to reverse.
Thank you very much. Appreciate the briefing and the arguments in this matter. We'll take it under advisement.